Now, I must tell you, I've told you, and quite frankly, in a passing remark to the President of the United States, I told him, if they ask for your private information, don't give it to them. Take it all the way to the Supreme Court. Congress has oversight responsibility for writing legislation. They're not criminal investigators. That's not their authority. Moreover, any business transactions of the past, don't give it to them. They don't have any authority over that. And then I see this piece in the Wall Street Journal on Valentine's Day by David Rivkin and Elizabeth Price Foley, and they're right on. Stop the impeachment fishing expedition. Congress has no business investigating the president for conduct that occurred before he took office. It's even broader than that. But they make another point, which was made by the Office of Legal Counsel that we've talked about many times here. They say the president is not one among many, as are legislators and judges. Crippling his ability to function upsets the constitutional balance of power. For this reason, the Justice Department's Office of Legal Counsel has repeatedly concluded a sitting president may not be indicted or prosecuted. The same logic should apply to congressional investigations. Congress is targeting Mr. Trump's actions before becoming president because there are well-established constitutional limits grounded in separation of powers doctrine on its ability to investigate his official conduct. In United States versus Nixon, a Supreme Court decision in 1974, the court recognized a constitutionally based, although not unlimited, privilege of confidentiality to ensure effective discharge of a president's powers. In Nixon versus Fitzgerald in 1982, the justices held that presidents and ex-presidents have absolute immunity against civil liability for official presidential acts. They go into the Clinton versus Jones decision of 1997, which is not relevant here. The court did, however, consider the question of whether civil litigation could conceivably hamper the president in conducting the duties of his office. It answered, if and when that should occur, the court's discretion would permit it to manage those actions in such fashion, including deferral of trial, that interference with the president's duties would not occur. Now, unfortunately, they write, the scenario that court called unlikely in 1997 now exists. Mr. Trump faces an investigation by a zealous prosecutor with unlimited resources, inquiring, among other things, into pre-presidential activities. In addition, Mr. Trump is subject to a deluge of lawsuits and investigations, including by state attorneys general involving his conduct before entering politics. The House Intelligence Committee has announced a wide-ranging investigation of 2 decades' worth of Mr. Trump's business dealings. The Ways and Means Committee plans to probe many of Mr. Trump's tax returns. By contrast, the 1995 resolution establishing the Senate Whitewater Committee targeted specific areas of possible improper conduct by the White House and federal banking regulators. And here's the nub. Congress has no authority to investigate or prosecute crimes. That responsibility belongs to the executive branch. It has no power to conduct fishing expeditions, and its investigatory authority is supposed to be in service of legislation, as we've talked about many times. Nor is investigating Mr. Trump's pre-presidential activities a legitimate exercise of the House's impeachment power. The framers viewed impeachment as a remedy for serious violations of public trust committed while in office. Gouverneur Morris told the Constitutional Convention impeachment would punish the president not as a man but as an officer, and punished only by degradation from his office. Alexander Hamilton likewise observed in Federalist No. 65, the impeachment involves those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of some public trust. So they don't have the power, they don't have the authority to look back, nor do they have the authority to delve into the president's personal finances for the hell of it, even while they create these pretexts. Well, we're going to make sure he's not, doing things in order to influence his business dealings. Sorry. That's BS. You've got no actual direct evidence of any of that. Fishing expedition. President should reject every committee request for any witnesses, family members, anybody from the White House, any documents, any electronic communications related to any of these matters, and go ahead and litigate it all the way to the United States Supreme Court. And I would advise the president, take your time. You're in no hurry. Take your time. I'll be right back.
Mark Levin.